By way of review, the previous rule issued by CMS stated that only licensed healthcare professionals would be eligible to enter orders into the CPOE system for meaningful use calculation purposes. The AAMA submitted written testimony, and partly because of our testimony, CMS changed its wording to allow, quote, credentialed medical assistants also to enter orders and have them count for meaningful use. When we talk about orders, we're referring to three types of orders: medication, laboratory, and radiology orders. Certainly, the AAMA was not the only party that submitted testimony, but I do believe that our role in this has been significant as the leader of the medical assisting profession. And as a result, the final wording of the rule did include credentialed medical assistants. I'd like to present to you a few definitions. This will help us understand some of the points I will be making in a few minutes. Some definitions. First of all, credential or credentialing. A credential is a general term that includes both licensure or licensing and certification. Credentialing is the broadest term that could be used to refer to professional regulations of any kind. More specifically, a license is defined as a mandatory credential. State or federal law would state that only those who have a license are permitted to do a certain thing, in our case this morning, to enter orders into the EHR. Certification is much different from licensure. By definition, certification is a voluntary credential. So when we're talking about credentialing, that's the broadest term, and two subcategories are licensing, which is mandatory, and certification, which is not mandatory. It's very important that we keep that distinction in mind. The final rule did say that licensed healthcare professionals, as well as credentialed medical assistants, could enter these three types of orders and have them count toward meaningful use. A question that I often receive, even these days in the executive office, is when did this go, or when will it go into effect? Some people are under the impression that it's not going into effect until January 1st, 2015. In reality, it went into effect January 1st, 2013. Some people have gotten the message late. Some people, frankly, have not wanted to believe that this is in effect. But the reality is, and it's very clear in the federal regulations, that this went into effect January 1st, 2013. Secondly, another piece of basic information, the CMS rule regarding order entry applies to all stages of the incentive program. There's a misconception that it only applies to stage 2 and not stage 1. That is not correct. This rule applies to all stages of the incentive programs. When there is a stage 3, which is planned, and assuming there will be a stage 3, this rule will still be in effect, again, highlighting the importance of credentialing for medical assistants. Now let's get into some specifics. CMS does state that credentialing for a medical assistant must come from an organization other than the organization employing the medical assistant. You may recall last year that Mr. Robert Anthony from CMS co-presented with me, and he emphasized the third-party nature of a credential in order for it to be acceptable under the CMS rule. Secondly, my best understanding of the rule is that a credential must require the passing of a test. And finally, once again, in-house credentials are not acceptable. So if a large medical system establishes its own training program and offers some sort of test and its own credential, that does not meet the CMS definition of credentialing for purposes of entering orders into the CPOE system. However, CMS does not answer specific questions about what is and is not an acceptable credential. Oftentimes, I have had to give my best legal interpretation as to the meaning of the CMS rule. In reality, CMS is actually referring callers and emailers to me because they're not willing to answer questions. This really is true because they are not willing to say anything. CMS staff cannot say anything under the law other than, well, it has to be a third party. If someone follows up with a question, well, what about this? They will say, I'm sorry, we have no direction in the rules. Why don't you contact the AAMA? They seem to have a good handle on this understanding. So out of necessity and duty to the AAMA and the medical assisting profession, I've been happy to study up and to provide answers to these questions. And I do want to address some specific issues now. And again, if any of you have questions, feel free to come to the mic or just call them out. There is a credential based in New England known as the Registered Medical Assistant. This is not the RMA of AMT. This credential in New England is awarded by the American Registry of Medical Assistants. Has anyone heard of the ARMA? Now, one thing I want to point out, and this is very important, I take the position that the RMA of the American Registry of Medical Assistants does not meet the CMS rule because it does not require the passing of an examination. The only thing it requires is the payment of a fee and a letter from a physician, maybe 2 letters, stating that this individual medical assistant is knowledgeable and competent in all of the duties that they list on the application. So when I get these questions, I have to say that it is my opinion that the RMA, and by the way, they have R period, M period, A period, unlike the AMT RMA, my best understanding of the law is that the ARMA, RMA does not meet the meaningful use requirement, and therefore someone who has that credential cannot enter orders into the CPOE system for meaningful use purposes. Do we have a question here?
Linda Prince, CMA, COA, New Hampshire. In the ophthalmology field, we have scribes that follow the doctors around and enter all the information as the doctors are repeating those. Are those scribes considered, because the doctor's in the room, are they considered licensed under the doctor? Is that with meaningful use or?
Thank you, Linda. That's a good question, and I do get that question. Medical scribes, to my knowledge, are not licensed in any jurisdiction. In fact, in the CMS rule, there was a statement that because there is no credentialing test for medical scribes, CMS was not willing to acknowledge medical scribes as meeting the requirement for credentialing. However, there have been credentialing examinations for medical scribes that have been presented in the last year and a half. I would have to say that whether medical scribes meet the requirement depends on 2 things. First of all, they have to be credentialed, not licensed because it doesn't exist, so certified. And secondly, they have to have the competencies that medical assistants have to enter orders. My position right now, Linda, is that medical scribes, even if they have a medical scribe credential, would not, by virtue of that fact, meet the CMS rule. We'd have to look at the outline of their certification examination to see what is tested, but I take the position until I can conclude otherwise that they would not meet those qualifications. Linda, do you know whether they're certified, these medical scribes, or do they just work under So they work. Okay, so the comment was that these medical scribes are right with the physician. They take the dictation and record it, and then the physician signs off, and then the scribe signs under the physician's name. To me, that's not enough information for me to say that that meets the CMS rule. So again, unless I can be shown otherwise, I don't believe that a medical scribe would fulfill the definition of credentialed medical assistant under the CMS rule. Yes, please.
Thank you. Thank you, Director Balasa. Leticia Velez, CMA, AAMA, State of Arizona. I understand that you're saying that we are able to order labs, medication, and radiology. Does that also include procedures and medical equipment that is handed to the patient in the office? Is that also part of the order entry?
The question again is whether the ordering of equipment falls within this. The answer to that is no. Only these three categories: medication, laboratory, and radiology orders. So that is beyond the scope. Equipment is beyond the scope of the CMS rule. And again, to clarify, credentialed medical assistants and licensed healthcare professionals are permitted to enter the orders as directed by the overseeing provider. They cannot do that on their own initiative, of course, or judgment. If a physician, a dentist, a physician assistant, a nurse practitioner gives an order, then credentialed medical assistants are permitted to enter that and have that count for meaningful use. Yes, Dawn.
So going back to the ARMA in New England, because as you well know, we're having that issue. We tell the employers how important it is. They have to take the exam, take the certification, AAMA, and they all look at us as if we have 10 heads. They said, no, they're registered, the doctor signed it. How can we break that barrier? How can we tell the employer, because they're not listening to me or anybody else who is a CMA? Suggestion.
Yes. How can people be persuaded that the RMA of the American Registry of Medical Assistants does not meet the qualifications? I would say that just giving them the one page from the federal regulations, and I will forward that to the Massachusetts Society, and just reading the 3 or 4 sentences that address this should be sufficient. I think that's the best answer, going right to the fundamental source, the primary source of CMS. They are the authority. They've been empowered by Congress to issue these regulations and enforce them. So I would say that's the best avenue. Not everyone obeys the law in the United States of America, unfortunately. I don't know if you're aware of that, but sad to say, that is the case. But if they disregard this law, they do so at their own peril, and they run the risk of having to forfeit or pay back payments under the incentive programs. Yes?
That was my answer right there.
Yes, thank you. The question and the answer is that if the CMS rule is not followed in any one point, one of them being who can enter orders, then CMS has the authority from Congress to audit and to require the provider to return payments as appropriate. Yes, Sarah.
Sarah Bear, Illinois Society. We have an oversight panel at our group, and it was my understanding that they were going to accept the R.M.A. So I will take your information back. But I guess because we had that panel, I didn't get too involved with the legalities of it. How does CMS know?
Yes, how does CMS know whether a medical assistant is credentialed or not? And Mr. Anthony did address that last year. Technically, they have the authority to come into the office and ask the provider to provide a printout of who entered each order. And as I will mention later, audits are already taking place. So Sarah, I guess my question would be that it really would depend on a CMS auditor who would ask for a list of who is entering the orders. They would have to make sure that a certain percentage is entered by credentialed medical assistants or licensed healthcare professionals in order for that threshold, that order entry threshold, to be met. Yes, Lori.
Yes, Director Balasa, Lori Rager Anderson, CMA AAMA from Utah. The question I have for you is if a state medical society, the Doctors Medical Society, has the right to protect us, or not to protect us, but to go against us by doing their own medical credentialing exam for in-state corporate entities.
Yes, question. Can a state medical society or any entity provide its own examination and state that those who pass this test are credentialed? The answer to that is yes, Lori. I know we don't want to hear that, but if this is truly a legitimate test by a third party, and in this case it would be, that would be acceptable under the CMS definition. The CMS, again, is not willing to take a specific stand on what credential is or is not accepted. So if it's a legitimate test, not 10 questions, for example, or not testing items unrelated to this area of knowledge, yes, that examination would meet the CMS requirement.
Thank you.
You're welcome. Let me talk about a few other specifics. In fact, one example is in regard to state medical societies. If a state medical society were to tell all of its physician members, if you send us $25, $50, write a letter stating that medical assistants A, B, and C are knowledgeable and competent in electronic order entry, we'll issue some sort of credential stating that these medical assistants passed their requirements and therefore are able to meet the CMS rule. In my opinion, the best I can understand the regulation is that that would not meet the CMS requirement. Even though in the law there are sometimes loopholes and legal fictions, a good maxim in the law is that the law regards substance rather than form. So if a physician were to submit a letter and then the state medical society were to issue something, in essence, that is still an in-house credential because it's based just on the opinion of a physician or more than one physician that this individual is competent to enter orders. So that's an example of a credential that I believe very strongly does not meet the CMS requirement. Now that's different from your question, Lori, because you said the state medical society is going to give a test. Is that correct? So that's a totally different situation. Okay. But again, a state medical society could not accept the word of the employing physician and then say, well, we're going to give a credential and therefore all of your medical assistants can enter orders and have them count for meaningful use. One other example, and I'll address the Washington State situation, but let's get some questions. Donna, please.
We had a question. You know, we all enter orders based on what doctor or nurse practitioner tells us. What about the verbal orders that they give? That would be on there too. We're just entering it in there. That doesn't have anything to do with us taking verbal orders from the doctor and then
That's right.
it.
The difference between a written order and a verbal order is not recognized by the CMS rule. A verbal order is acceptable.
Okay. And then I had another question. When I work in a hospital and a doctor's office, in the hospital, when they sign somebody new for the medical record, if you have credentials after your name, you have access to different parts of the chart. So if I'm just a unit secretary, I can order some things, but I would not be able to order, you know, a lab test or anything that because a credential is locked into what you can legally do.
Yes, so that's a self-policing mechanism. Yes, good to hear. Thank you. In the back.
Rodriguez, CMA AAMA, alternate from Connecticut. And my question when we talk about the credentialing, am I correct in assuming by this then that an RMA does meet this, an RMA certified by the AMT does meet the qualification?
Yes, an RMA credentialed by AMT does meet the CMS definition of credentialed medical assistant. Once again, however, it's my position that an RMA from the ARMA does not meet the CMS requirement. Yes, Lisa.
South CMA, Maryland, would it behoove us to contact our congressmen, congresspeople, or senators to give our opinion? Every time they get a question, they have to address it. So if all of us started pounding Congress about this issue with credentialing, it might do some good.
Yes, I agree. It would be worthwhile for each of you, when you encounter a situation in which the law may be violated, to write to your United States legislators and indicate that the CMS rule is not being obeyed, and therefore they should be aware of that, and perhaps even change the legislation so that it would address this more specifically. To Washington State. Washington State has different categories of credentials. They used to have the healthcare assistant, HCA. By their legislative action, they created different categories of medical assistants. The MA-C is the highest level, and that requires education and the passing of an examination. There's a level of MA-R, medical assistant registered. In order to get that credential, all that is required is that the physician submit in writing the opinion that this medical assistant is competent in a list of duties. The question arises, under federal law, is a Washington State MAR a credentialed medical assistant? It's my opinion that an MAR is not, because once again, there is no test, there's no educational element, it's just the opinion of a physician that this individual is knowledgeable. In essence, isn't that the same as an in-house credential? You're just going through a third party, in this case, the State of Washington Department of Health. But I take the position, and I've gone on record in Washington State on this, that an MAR does not meet the definition of a credentialed medical assistant. Yes, Shelley.
Yeah, CMA AAMA, Washington State Vice President. And at my large multi-specialty facility, our CEO, who is a physician, signed off on 80 to 100 receptionists, created all of them as MARs. They have had no education other than HIV awareness training. That's it. And on the job. And they're now all MARs. I mean, I know that this is wrong. What can we do?
Yes, in reality, I think those of us who testified at the level, Pat Hightower, Tom Wolf, and some other folks, pointed out to the Department of Health as it was drafting its regulation that this was a potential danger. The department decided to not heed our warning, and then we're seeing things like this. I think this should be pointed out, Shelley, first of all, to the Department of Health. It may even be necessary to contact Washington State legislators and bring this to their attention as well. So that would be my best recommendation.
Thank
the
you.
importance, you're welcome, of having good laws at the state level. I work with many of you in regard to scope of practice, right to practice. It's important that those laws be very carefully worded, or you could end up with something such as what Shelley described. All right, let's move on to another point of great importance. Is someone with a non-current CMA AAMA, a credentialed medical assistant? Emphatically no, because the certifying board clearly states in its policy that a CMA AAMA who is not current cannot use the credential for any purpose. Therefore, some of you might encounter or might know of CMAs AAMA who have not recertified. That individual, according to CMS law, is no different from a non-credentialed medical assistant because the certifying board says that that individual cannot use the credential. So keep that in mind if someone says, well, I obtained my CMA 15 years ago, I recertified once, but I've not been current for 10 years. That individual does not meet the CMS definition and therefore cannot enter records or orders for meaningful use purposes. It should be noted that we're seeing a lot of people recertify their CMA AAMA because they realize that they cannot use it for meaningful use calculation purposes. So please feel free to inform any of your colleagues who may be lapsed CMAs AAMA that they cannot enter orders and have them count for meaningful use. Yes, Denise?
As you know, I work for a large employer in Wisconsin called Aurora. It's like 30,000 employees. For 25 years, 28 years, I've been saying, CMA, you need to get them credentialed. And they haven't really listened. And finally, last week, they came to me and said, what do you know about this ruling and the credentialing? So finally, all these years, and they said, you know, because they knew about my BOT experience and stuff. So you may be getting some calls from my people. And I've directed them to your website, our website, and finally, they're listening. So you can't give up. 28 years.
Yes, your patience has been rewarded, so we applaud you for that. All right, next slide, some very important information. I'm quoting here from a CMS frequently asked question, which is available on the CMS website. They were getting questions about what about individuals who do not have medical assistant in their title? Can those individuals be considered credentialed medical assistants for order entry purposes? Here is what the CMS FAQ said. The individual must be appropriately credentialed, point number one, and perform similar assistive services as a medical assistant. That is one criterion that must be met in order for someone who does not have medical assistant in her or his title to fall under the credential definitions of CMS. Secondly, must be credentialed to perform the medical assistant services by an organization other than the employing organization. Note there, to perform the medical assisting services. So the individual must be appropriately credentialed, but not any credential. Must be appropriately credentialed to perform the medical assistant services. And in this context, entering orders into the CPOE system. So this is the requirement that CMS has set up for those who have titles other than medical assistants. Note this third point, each provider must evaluate his or her own ordering workflow, including the use of CPOE to ensure compliance with all applicable federal, state, and local law and professional guidelines. Some examples, certified ophthalmic assistants, certified dental assistants, because the program does cover doctors of dental medicine, as well as physicians and osteopaths and many other providers. But here's the issue, and many of you have directed questions to me. What about a certified nursing assistant? What about a certified phlebotomist? What about a rad tech, radiologic technologist? What about an EMT? I have been bombarded with questions as to how to apply the CMS definition to these people who are not per se medical assistants. The way I answer that is to point them to this FAQ and state that, first of all, the individual must be appropriately credentialed. And I take the position that applies to licensure as well as certification. If someone is credentialed, even licensed in an area that has nothing to do with electronic order entry, I don't believe that that meets the CMS requirement. So first of all, look at each individual. Is the credential that that person has appropriate for, again, performing medical assisting services, in this context, entering orders into the CPOE system? You could make an argument that certified nursing assistants would not meet that requirement, even though they have a mandatory credential. I don't see a fit between that and what medical assistants do, a complete fit in regard to order entry. Some of these other professionals certainly have a better argument. Someone who is a radiologic technologist, an EMT, you can make the argument that they are appropriately credentialed. In some cases, they're licensed. But a phlebotomist, for example, I don't see a good mesh between the competencies and the knowledge of a phlebotomist and what a credentialed medical assistant has to know in order to enter orders and meet the CMS requirements. Have any of you encountered situations with these other related professionals and whether they can be considered credentialed for CMS purposes? Any comments or questions? Yes, Donna.
Reds in Illinois. I know DuPage Medical Group, you know, the big out by us, has 450 doctors at several sites. And I know in their immediate care and urgent care, they have EMTs working, triaging the patients and putting them in the room. And then they have a nurse above so many EMTs.
Right. Are they doing order entry as well?
I would think so, because when I was there, they're the ones that are, you know, taking care of you and doing everything in the room and putting everything in.
If I had to make a call, an EMT would probably meet this. But again, there are other categories, many other categories that would not. Yes, in the back there. Tandra?
Tandra Bauman, CMA AAMA from Wisconsin. I worked at a huge facility, Mayo Clinic in La Crosse, and Mayo Rochester does not hire CMAs. So the satellite clinics are basically going away from CMA, or MAs are what they're considering. They don't really look at our credentials. And after taking a medical leave, I was told the day that I left that when I came back, I would be considered an expert roomer. The RNs, I would just basically go in, room the patient, take the vitals. I was not allowed to go in and unroom the patient after the physician saw the patient, or put in any medications, any orders. I think this is how the big facilities may get away from that, but luckily I got another job, so I don't have to worry about it anymore.
Yes, thank you, Tandra. And you know, interestingly, there are a lot of large healthcare systems that are going in the other direction, so it's very confusing. It depends on the region of the country, and even within a particular city or state or county, it can differ. But we should be aware of and be able to educate people as to the value of the CMA AAMA credential, especially in light of the CMS rule. The core objectives, I'm not going to go over those. The next slide, very important. Will the CMS enforce the credentialed medical assistant requirement? You can go to my article on our website and see the fact that CMS auditors can enforce it. They have the authority. And in fact, there have been visits, audit visits, that have started in certain parts of the country. So as a result, you just need to be aware that this is not something that's going to be unenforced. Also, one other point that just emerged in the last few weeks, there are some physician groups that are urging CMS to delay the implementation of some of these provisions. They're arguing for more flexibility in the CMS rules. We'll have to see whether that goes into effect. But right now, the CMS rule is as it was published in the Federal Register, and it must be obeyed. Yes, sir.
Fred Clough, CMA AAMA, State of Maine. I wanted to clarify, our PSRs were directed to go to the AAMA website for certain training to be allowed to do certain EMR entry. Does that cover the orders? If one of our providers send them, please order a follow-up lipid panel in 6 months.
Yes, you're referring to the ABROE that is being offered.
Correct.
It is my opinion that that does satisfy the CMS definition of credentialed medical assistants. I will address that this afternoon and this evening, but that does meet the CMS definition because it is an educational component and it also has post-tests and therefore would meet the CMS definition.
Thank you.
Yes, Sherry.
Thanks, Don. Sherry Grimes, Washington State President, CMA, and a whole bunch of other credentials. But what I'm concerned about is there is a convoluted mess in Washington State with grandfathering of the ACAs to the MAC certification. And I want to know if we could start a process of auditing those that were just grandfathered in and they have no educational.
Yes, you know, if CMS were to get word of that, I believe it would enforce that. So, yes, I think the Department of Health should be aware of the federal regulations, and perhaps they would be mindful of that. And I believe that a CMS auditor would look at that very carefully, because someone who doesn't have education has not taken a test because the HCA did not require the passing of a test. I believe that that does not fall within the definition of credentialed medical assistant.
Thank you, sir.
You're welcome. Are the incentive programs mandatory? And the reason I use the plural here is because the Medicare and Medicaid programs are actually two separate programs. Technically, they're not mandatory at this point in time, but as you see, there will be financial disincentives that go into effect in 2015 that would make it very expensive for a provider to not participate in the program. Yes, please.
Yes, you mentioned that CMS is beginning the auditing of facilities. How can they do that, sir, if they're having to refer people to you to figure out whether or not their credentialing meets their own criteria?
Well, that's a very good question. Maybe the auditors will contact me when they're on their audit as well. And I'll be happy to help out the auditors, but you raise a good question. A key point, very important point. A current CMA AAMA, again, not a non-current CMA AAMA, which is sort of an oxymoron actually, meets the CMS definition of credentialed medical assistant and does not need anything else to be able to enter orders into the EHR and have such entry count toward meaningful use. An important point, I sometimes get questions from employers, from human resource personnel that are saying that, well, even though these employees have a current CMA AAMA, I don't think that meets the CMS guideline. And I have to argue very forcefully that the plain language of the regulation does indicate that a current CMA AAMA does meet the guideline. Are there any other questions or comments? Feel free to, again, come to a microphone or just speak them aloud, and I will address them. Yes, please.
Holly Griffith, CMA, Michigan. I have a coworker that came from an accredited school many, many, many years ago, but was never certified, but would like to be. I've heard through the grapevine that she cannot take the test after so many years. Can you clarify that for me?
I'll be happy to clarify that, and we get this question repeatedly in the executive office. Anna answers many of these questions. The certifying board policy is that any individual who graduated from a CAHEP or an ABHES accredited program on or after January 1st, 2010 must take and pass the examination within 60 months of graduation. However, anyone who graduated prior to January 1st, 2010 has no time limit on when the individual can take and pass the test. So we get calls, I graduated in 2005, I missed the opportunity, the 60-month window. There's no 60-month deadline for anyone who graduated prior to January 1st, 2010. When did these people graduate? Do you know?
It's been probably 20 years.
So they are not affected by the certifying board policy. If they graduated from a CAHEP or an ABHES accredited program in 1980 and never took the test, they are eligible, and there's no deadline on the eligibility to sit for the CMA AAMA certification examination if they graduated from a KHEP or an ABHES accredited program prior to January 1st, 2010.
Okay, thank you.
So please get that word out. That's a common point of misunderstanding. Yes, please.
Donna Pacello, CMA, AAMA from the state of New Hampshire. When I was employed, they put MA after my name. I went back and had my badge changed. They allowed CMA, but they refused to put AAMA on there. They said the hospital did not approve it. So what do I do? Can I fight this, or should I?
Yes, you can fight that. I would suggest that you send me the name and the address of a person in authority, and I can write a letter.
Thank you.
And I do write these letters frequently, maybe one every other week, pointing out, and as you've seen in my article in the September-October issue, the fact that the CMA AAMA is now registered on the federal registry, so we do have official additional protection for the credential, but I would be happy to write a letter to that effect. Yes, Andy.
Thanks, Don. Andy McPhee from F.A. Davis. Don, can I go back to the scribe issue for a moment?
Yes.
If the scribe is in the office taking the dictation, and they give an MA, a CMA in the front office, for example, that dictation about an order, and that CMA can enter it, but it came from the scribe. How does that?
Yes, Andy, that's a good question. Yes, that would be all right as long as the provider, the physician, whomever has signed off on that order, even though the scribe is the one that actually took down the order. As long as the provider reviewed, approved, then it would be permissible for a credentialed medical assistant to enter that order into the CPOE system. Other questions? And another important point. Some people are taking the position that graduation from a medical assisting program does meet the definition of credentialed medical assistant. In fact, Mr. Anthony stated that last year. I take the position that graduation from an academic program is not sufficient. My reading of the regulation is that there has to be the taking and passing of an examination. Now, again, people can disagree over that point, but that's my best understanding of the CMS rule. Graduating from an academic medical assisting program is not sufficient. Yes, Marcia.
Marcia Benedict, Florida Society. I'm very excited to let you know that the Martin Health System in Florida has decided to hire only CMAs. They have 70 CMAs, or were previous CMAs, who let their credential lapse, or some of them didn't take the test after they graduated from a KHEP program. So beginning Monday when I get home, I will be doing a review class for those 70 students, a few at a time, online, so that they can get their CMA again due to this requirement. And I'm really excited about that.
That's wonderful. Congratulations. Tandra, I know you've got another job, but if you hadn't, you could move to Florida and you'd be you'd be more than an expert roomer. That was your time. Okay, yes, Linda.
Unfortunately, back to the scribe issue again. If the scribe does not put his name, because both my scribes happen to be male, does not put the name in the chart and they're just dictating from the doctor, typing in the dictations, because that's what they told me why the scribe was okay, because they're signing off under the doctor's name and their name isn't in there anywhere.
Are they actually entering the orders, medication lab or radiology orders, into?
As the doctor is dictating, they're entering in the orders because it's all completely computerized.
Yes, again, we can play back excerpts from Rob Anthony's presentation last year. That is not acceptable. The person who is actually doing the CPOE has to meet the qualifications. Some of you remember how adamant he was on that. He also said that if it's an issue of entering anything else into the EHR, demographic information, financial information, lists of medication, he said anyone can do that. A layperson could do that. But those three categories of orders have to be entered by either a licensed healthcare professional or a credentialed medical assistant.
Thank you.
You're welcome. Yes, Carol.
I believe there is language in CMS regarding the use of scribes and that there is a statement that must appear at the end of the documentation, including electronic medical records that so-and-so was the scribe for Dr. so-and-so or provider so-and-so, and then that provider must sign off on it.
Yes, yes. Could you repeat that into the microphone? Very important point. I'm not as familiar about this aspect of the law. Please.
There is language on the CMS website regarding the use of scribes, and there is a specific statement that is required under CMS rules that is to be placed in the medical record, whether it is an EMR record or a paper record, that I so-and-so scribed for Dr. so-and-so or provider so-and-so, and that name must appear in that blank. And then that provider who was the orderer must sign off that that scribe was present in the room when that transcription took place. So I think if you will refer to the CMS website, you will see that there is strict definition on that, and it must be followed.
Thank you very much, Carol. Are there any final questions? Yes.
In the EHR systems that we have, that we currently use, the physician sends the order to the medical assistant or sends it to the administrative assistant when it comes to prescription refills. And so they are calling in, or they are entering that order after the physician really already entered the order. They are processing that order into the system in Iowa.
Yes, that is a different situation. So you mentioned that the physician enters and then the medical assistant enters. Could you explain exactly who is doing what? That's
well,
important.
The physician okays the prescription. It's sent to them initially by the administrative assistant, the front desk, the MA, whoever takes the call. The patient's requesting a refill. So that goes to the provider. The provider then okays that prescription. It's then electronically sent back to should be sent back to the medical assistant, but a lot of time it's sent back to the administrative assistant. And in Iowa, anyone can call in a script.
Yes. Now, my response to that is that would not meet the CMS requirement. Remember, again, Mr. Anthony said that the individual who actually enters the order has to be either a licensed healthcare professional or a credentialed medical assistant, because that individual is the one who sees the clinical decision support alerts. And a layperson, an administrative assistant, would not meet that definition. So even though the provider is approving, it's not countable for meaningful use unless the individual entering is a credentialed medical assistant or a licensed healthcare professional.
Then that would also affect with any orders that are going over for hospital labs, x-rays, procedures. Even though the physician is putting the order in, it's who's processing that order out and giving instructions, correct?
Yes, if the provider were the one that was actually entering the order into the EHR and actually saw the clinical decision support alerts, that would be acceptable. Yeah. But the scenario you're describing is different.
Correct.
So I would have to say that CMS would not accept that. That's my best legal judgment at this point.
Thank you.
You're welcome. Microphone 2.
Okay, Susan Bobbitt, CMAC, AAMA. If someone has graduated from an accredited program, taken the certification exam years ago, and let their certification lapse, what is the procedure to reinstate that certification? I've had that asked me from my former employer.
Yes, here's the answer to that question. If the CMA AAMA credential has lapsed for less than 60 months, that individual is still allowed to recertify by continuing education. However, if that CMA AAMA has been not current for more than 60 months, that individual must take and pass the CMA AAMA certification examination in order to regain currency.
So they are still able to take the exam again if it has been more than 60 months and reinstated?
That is true. Okay. No one is forbidden from recertifying by examination.
Okay.
Even if the credential has been lapsed for 30 years. But if it's been lapsed for more than 60 months, examination is the only recertification method, not continuing education. Microphone 3.
Hi, Barbara Falstrom, CMA, AAMA, Washington State. I have taken a lot of this information to like the corporate managers because I know that we're in violation of the ruling. They kind of, I guess, believe that doesn't apply to them, or they have the attitude, well, we'll wait and see. You know, maybe waiting to be audited. I guess I'm looking at what is the consequences. I understand that you said, you know, we would have to pay back. I mean, I guess I would like to hear from you a clarification of what the consequences would be that I could share with them instead of this, well, let's wait until we get caught attitude.
Yes, yes. Unfortunately, again, not everyone in the United States, believe it or not, obeys the law. I know that's hard for some of you to believe, but I guess it's true. All right, this slide addresses that. All core objectives must be met in order for an eligible professional to receive the incentive payments, and failure to meet even one core objective results in non-receipt of the entire incentive payment. So it's not just a pro rata deduction or recoupment. If there is one core objective that is not met, then the incentive payment is zero. And again, I can hear in my head Robert Anthony saying that very poignantly last year. So therefore, order entry by someone other than a credentialed medical assistant or a licensed healthcare professional in a sufficient proportion to meet the CMS requirement could lead to forfeiture of the entire incentive payments and payback of anyone's in the past. Does that answer your question?
Yeah, thank you.
Yes, Jen, microphone 1.
Hi, Jen Amaral, Connecticut State Society. Is there like a whistleblower program where we could contact them? Because the only way you learn is when you get slapped on the wrist or it hurts a doctor's pocket, is when they start actually paying attention. So is there any way that we could report them for not following the rules?
To my knowledge, there is no specific whistleblowing provision, but you or anyone can inform CMS if the regulation is not being followed.
So we can contact CMS and let them know that we know what is going on, and then they can initiate an audit, basically?
Yes, you can, yes. There's a separate section under the CMS website in regard to the meaningful use incentive programs. So yes, you can report that.
Okay, thank you.
Very good. Okay, microphone 4.
My question is, at our office, they have a certified medical assistant putting the order in the computer. They do not have somebody that has certification actually calling the hospital and making those arrangements. And that's how they figured that they could get around that. So they have like a lab and x-ray desk. So the medical assistant enters the CBC, whatever, CT scan in the, order in the computer in the room, and then she tasks it over to the lab x-ray desk, who actually prints that stuff out and calls the hospital and says, I need a CT scan on Mrs. So-and-so, and she gets that information. So my understanding
might be
from...
all right. So the medical assistant is the one, or the credentialed medical assistant is the one who enters the order.
Yeah.
Does that individual see the clinical decision support alerts? That's the key question. Do you know whether that person would be the one who sees any contraindications or any issues? Because if that individual does, but then has someone else call it in or whatever, that's all right, as long as the individual who sees the CMS clinical decision support alerts is credentialed medical assistant or a licensed provider.
Okay. My second question is from earlier on, where you were talking about other entities like CSTs and our rad techs, and you were saying that rad techs were fine. I work in a...
That's my opinion, yes.
I work in a we have like 22 surgeons in our office, and probably half of the girls that do the same job as I do are surge techs. They are certified surge techs that came from the hospital over. Would they fall under the same?
Certified surgical technologists, first of all, if they are certified, and I know there is a credential that is offered, my initial reaction would be that that would qualify under the CMS language.
Okay.
Very good. Okay. Microphone 5.
Hi, Amy Wicker, CMA AAMA, Ohio. I just want to kind of go back to the prescription, and I apologize if you did answer this, but my corporation was kind of looking at, we have a pre-service department that schedules appointments and things for patients for all of our offices, and they were looking at having them enter prescription refill requests if a patient called in. So my understanding is they would, if they are not a credentialed medical assistant, they could not enter that request, and once they enter it, it routes to the physician for approval, but they're entering in it's an order, because all the doctor then has to do is click yes to sign, and it goes to the pharmacy.
Yes, does the physician see the clinical decision support alert?
He would before he signed, yes.
In that case, that is acceptable, because the physician as a licensed professional is the one that is seeing the alert, so that would be acceptable.
Okay, so they can enter first as long as it's going to the physician for approval.
That's right, and so the physician is the one that actually transmits the order. So yes, that would be acceptable. Yes, Tandra, you have the last word this morning.
Is your PowerPoint going to be online?
Yes, it will be, and in fact, an article accompanying this is already online.
Okay.
So if you want to see my article, if you have access here, you can actually see that article. And yes, this will be online. It may even be online already.
Second question. Do you foresee CMA, could we change that to maybe credentialed medical assistant or CCMA, credential certified medical assistant, to make us stand out beyond just regular MAs?
You know, my answer, Tandra, is that probably would not be the best way to distinguish the CMA AAMA from other credentials. The fact that our credential is the only one that requires completion of an educational program is a point of distinction. So I don't see any change in that way in regard to the initialism or the title of the credential as being prudent or forthcoming.